Now is the time and place to hear the appeal of discipline filed by a police officer. The hearing is confidential under Penal Code 832.7 and Copley Press v. Superior Court 39 Cal 4th 1272 2006. California Government Code Section 54957B1 provides that consideration of public employee discipline will be conducted in a closed session unless the employee requests to have the hearing in open session. The police officer received their notice of their right to have this hearing in open session. Counsel for the employee confirmed the request for an open hearing at the pre-hearing conference on July 31st, 2025. This hearing is a continuation of the hearing for police officer Julian Vazquez. Before we begin the hearing, we will take public comments. Please note we anticipate this hearing to span multiple hearing nights, and each member of the public will only be given one opportunity to comment on this item, meaning if you have previously commented that you cannot comment again, and if you comment tonight, you cannot comment on this item in a future hearing date. If there's anyone in the public that would like to be heard, please raise your hand at this time. If you could please approach the podium. Thank you. If you would like to state your name before you speak, please do so now.
My name is Kathy Lawson. I am Julian's aunt. I have worked as a human resources professional for more than 30 years and have extensive experience reviewing employee conduct, disciplinary actions, and termination decisions. After observing these hearings, I did not see any evidence of assault, excessive force, or any conduct that would justify termination. It is clear to me that none of the other officers present at the incidents believed Julian was acting unlawfully. If they had observed misconduct or policy violations, I would expect that they would have intervened or reported it at that time. I have also seen no evidence during these hearings that Julian engaged in any conduct that would undermine or destroy the public's trust. There are no negative performance evaluations, counselings, records, disciplinary actions, write-ups, or warnings that show a pattern of misconduct or poor judgment. Instead, I have seen evidence of positive performance, including supervisory approvals of reports and arrests that Julian has made. Based on what has been presented in these hearings, I believe this termination was a mistake. I respectfully ask that you reconsider this decision, reinstate Julian to his position, and clear his name. Thank you for your time and consideration.
Thank you. And again, if you would like to state your name, you may do so now.
Hi, my name is Josefina Vazquez, and I am Julian's grandmother. I am sorry, my English is not very good. My grandson is a good man, a good son, and a good father. He is also a good police officer. This makes me sad. I don't understand why this is happening. But I know Julian and he didn't do anything wrong. I am very proud of my children, grandchildren, and great-grandchildren. We are a close family. I hope you consider my grandson for his job back. Thank you. God bless.
Is there anybody else that wishes to speak on this matter at this time? Seeing no one. All parties from the previous hearing dates are present. Police Officer Julian Vazquez is represented by Tom Yu. The Police Department is represented by Nicholas Grether. Formal rules of evidence need not apply. However, the Commission shall exclude incompetent, irrelevant, and immaterial evidence. Any procedural requests or motions should have been made before the hearing, but the commission will consider a request or motion that was not evident until after the hearing has begun. Does either party have a request or motion?
No, thank you.
Mr. Grether?
No.
Mr. Grether, are you prepared to recall witness Danny Santana?
I apologize, Chair Lonis. I will jump in with a procedural motion. Mr. Yu, if we can go over your request for additional witnesses at this time.
Sure.
Thank you so much. And if that is helpful, I can reference that staff received a request for subpoenaing of witnesses on May 21st for the following individuals: Lucas Rayono, Jeffrey Clark, Robert Dunn, and Ryan Schmitz, as well as Arlen Wells, who was previously subpoenaed as a witness. The 4 requested subpoenas were not identified during the pre-hearing conference. Any exhibits or witnesses not agreed to during that time, and that then come before the commission once the hearing has started, are within the commission's purview to determine if they will be admitted into the hearing. So I can turn things over to the parties to provide statements regarding the request, and then the commission will have the ability to ask questions and make a determination.
Mr. Yu, and if you could
Sure.
just provide the rationale for the late introduction of these witnesses to the
Sure.
commission. Thank you.
Thank you. Thank you very much. They're actually not late introduction. These individuals were in the, well, I'll go in turn of why I am seeking a call, but 3 of the 4 witnesses are not belated introduction. They were all part of the investigation. I'll go in turn. Officer Jeffrey Clark was in the Mr. Hernandez incident. And when I was questioning the witness last week, if y'all can remember, counsel objected on some personnel file or pitches law that protects officer confidentiality. And I made an offer of proof that I would just call the officer. Officer Clark was my client's partner on the day of the incident. He was the driver of that incident with Mr. Hernandez. And Officer Clark is still employed by Torrance Police Department. I believe what Officer Clark will come and testify is that he was my client's partner on September 2nd, 2022. Officer Clark would tell you that he was driving the vehicle that day. Officer Clark is expected to testify that.
If I could, I don't need you to describe what they will testify to necessarily. It's just, I think it would be sufficient if you just said the matter arose during the hearing, and I'm looking for a little bit more rationale, not necessarily exactly what
Sure.
you think they're going to say.
Well,
If that makes sense.
I was going to provide an offer of proof and then give the rationale, but I'll jump to the rationale. The rationale is that when counsel objected and it was sustained, that I could not go through the witness, Mr. Santana, to ascertain whether or not Officer Clark would make the same mistake as my client, whether or not he was still employed. So I have subpoenaed Officer Clark to testify to that. I did not know at the pre-hearing conference that counsel for the police department would object to a very simple question of whether or not Officer Clark is still employed by the Torrance Police Department. So I'm gonna call Officer Clark for that purpose. I'll next move on. There's a couple witnesses, so if you don't mind, I'll go in turn. The next witness I'm gonna call is Sergeant Ryan Schmitz, SCHMITZ. Sergeant Schmitz authored the initial administrative review on the Mr. Garcia incident. I did not expect multiple witnesses to deny that the statute of limitations started and began on July 28, 2023. Sergeant Schmitz was served to impeach the testimony of Lieutenant Charles Fisher and Mr. Santana. impeachment witnesses do not need to be disclosed during a pre-hearing conference. And to be very transparent, the police department cannot say that they are prejudiced because these names were identified in the report. Schmitz was not interviewed by Internal Affairs, but his name and the report were all part of the investigation. Counsel will not, I expect him not to say that this is a surprise or that they didn't know who Ryan Schmitz was. Next, I'm seeking to call Detective Ryono, Ryono. His first name is Lucas, Lucas. He's the only witness that has not been identified, but since the hearing has commenced, I am informed that Detective Ryono authored an email to the captains and the chiefs and multiple supervisors of Torrance PD pertaining to the vehicle pat-down searches on that issue. If the commissioner recalls, that was a disputed issue on the Miguel Maldonado incident. And what Detective Ryono will come in to do is impeach, in other words, contradict, and provide different kind of evidence to this body than what Mr. Santana and Lieutenant Vazquez has testified. I did not expect that Lieutenant Vazquez would testify falsely to what I believe the truth is on vehicle pat-downs. So Detective Ryono was served as an impeachment witness to Lieutenant Vazquez. And finally, on Chief Dunn, there's an exhibit I'm going to introduce. I will defer that. I think if Mr. Santana testifies to that exhibit, then I don't need Chief Dunn.
Thank you. Mr. Gother, do you have any response to these witnesses?
Yeah, sure. I mean, I don't think we heard on
Arlen Wells was and since you brought that up, and I actually forgot to address that. Sergeant Wells was on my witness list. I do plan on calling him. However, I agree with counsel that I wanted to address this issue first because my preference was not to call Sergeant Wells first. My preference was to call Sergeant Schmitz first, and I agree with counsel that I wanted the commission to rule on this issue first before calling Sergeant Schmitz to come and I didn't want Sergeant Schmitz to come and wait around and risk if the commission doesn't allow him to testify, then I didn't want to waste his time.
Thank you. Mr. Gother.
Yes, thank you, Commissioner. The issues with Officer Clark and Sergeant Schmitz, I think that is the issue is that they were well known to counsel. They've been well known since the Skelly packets were sent to them that these individuals were involved. So there really isn't anything later asked. If the only question is whether or not Officer Clark is employed, I think we can handle that relatively easily. I don't know that necessarily Mr. Santana has direct knowledge of that, but the objections were related to any sort of disciplinary or personnel type history. So I don't know why the commission would then sustain those objections and then just allow the testimony to come in through some other way. It's not like a hearsay objection. So I don't think that's necessary. He was interviewed. His testimony is already part of the record essentially from his internal affairs interview. As far as Sergeant Schmitz, again, he was well known to everyone. We have his administrative review, which is part of the record. I don't think my recollection of the statute of limitations issue is not that it was not started as of July 28th. It's very clear in the notice of intent that there was a finding that it was told by a different subsection, not that it was later discovered. So I don't think that testimony would be necessary as far as that, and it's not something that was later discovered. As for, I guess I don't know what we'll see about Chief Dunn, what that is expected to be. As far as Detective Ryono, he has, I guess, a different opinion of some of this. He wasn't involved in any part of this factually. He did not issue any sort of opinion at the time. I suppose we could find other people and ask, I'm sure a public defender would have a different view of what the law would be, but I don't think it really adds anything to the case. I believe that email was identified as an exhibit a few months ago, and I don't think there was any request for a subpoena until May. So I don't see that was necessarily any sort of surprise based on any sort of testimony at this time. So I would just offer that we don't add any additional witnesses and we just move forward with it.
Could I respond since it's essentially my burden to persuade y'all?
Yes.
If you all remember, I know it's been a long time, it's been a lot of hearing nights, but there was a witness that testified before you who was not even part of the case. The use of force expert was not interviewed, was not even part of the decision-making process, and he was allowed to testify on his opinion. Detective Riano would testify to how officers are trained. I believe we're here to seek for the truth. If we're seeking for the truth, what we must do is we must allow some witnesses to testify of how officers are trained. Now, you might want to ask, well, why wasn't this discussed? Because remember, I asked Jason Masalkas, I said, how are officers trained? And what he said, well, we're trained not to allow officers to do a pat down. Now, it's my case in chief now. So I believe I get to make some decisions on who I call and when I call them. So Detective Riano will come in and tell you this is how officers are trained in vehicle pat downs. These are what we provide to the officers with the law that was provided to us. I think counsel is gravely mistaken on the difference between witness being identified versus what impeachment witnesses are. Impeachment witnesses meaning when we're sitting down for the pure hearing conference, this is before any testimony is being taken. I did not know, I would not have known or expected that Lieutenant Masalkas or Fisher and Lieutenant Krombach to come in here and tell you that the statute of limitation did not start that day. That is a huge issue in this case because I believe if we're going to hold Officer Vazquez accountable for his actions, then we must also examine the police department's actions. And those witnesses will come in to serve to contradict the testimony of Krombach, Masalkas, and also and Lieutenant Fisher. And I believe those witnesses, although known to me, but I didn't know what was Krombach, Masalkas, and Fisher's testimony because they were not interviewed by anyone. I didn't have their testimony. It is their testimony, Krombach, Masalkas, and Fisher, that I would invite you to measure against, not Schmitz and not Clark. Officer Clark will come in and say, hey, look, I did the exact same thing Julian did. I didn't get fired. I got no discipline. He's going to tell you that. Submit.
Thank you, Mr. Bent. Do you have any?
So I have an inquiry. I know you prevented this, you can give an offer of proof, but with respect to, I read the email that you sought to introduce me with respect to Lucas Riona, if I'm pronouncing it correctly.
Yes.
Is the offer of proof that he's going to testify with respect to what's in the email or something different and just training?
Well, what I think I was beginning to provide that. The contents in the email is analogous to the training, but the email I think is the roadmap of what the laws are and why Lieutenant Masalkas testified falsely. But I would like for Detective Riano to provide the training that he provides. He's an instructor. He's also a licensed attorney in the state of California, authorized to practice law. And I believe he's going to provide the training and contradict what Lieutenant Masalkas and probably what Mr. Santana will testify this evening.
So effectively, you're looking to elicit expert testimony from this witness with respect to Pat.
No. I don't think this is an expert opinion. He's not going to opine. I don't think Detective Riano would opine on the ultimate fact. I would ask him, I don't have the email in front of me, but something like, do you provide training to police officers? If so, what are the kind of training you provide? Have you reviewed the case law that the Torrance Police Department has cited in the legal source book? And he would tell the commissioners how police officers are trained in ensuring that a suspect does not use a gun to shoot and kill a police officer after a suspect gets released from a detention. He would testify and provide commission the type of training officers at Torrance PD receive in relationship to what the law is. I don't think that's a expert testimony.
But knowing that one of the issues in this case was whether the pat-down was considered lawful or unlawful, why the delay in not disclosing the individual to discuss this before it was started?
The testimony of, well, first off, because the decision maker hasn't testified on that issue, but I did not know what Jason Vazquez was going to testify. If you remember, Jason Vazquez opined, and I can go back and we have his testimony. I can cite the commission if you want, but I'm going to need some time. Exactly what I asked of Jason Vazquez in respect to the vehicle pat-down issues. I expected Vazquez to say, according to what the cases say and the training, which is we do train officers to do a pat-down before we release the suspect out in the field, because that is how officers are trained. I expected that. I did not expect Vazquez to say, no, that's illegal, or that's against policy. I did not expect that. If you're asking why didn't I subpoena Detective Riono, that's because it wasn't my case in chief yet. My case in chief is I haven't even had the opportunity to present a case. I don't think I don't know if that's your inquiry.
That was not my point.
Okay, then I misunderstood you.
Obviously, one of the issues, there's a lot of issues in this case, right? Whether there was use of force for the that was an issue that both parties knew and would be the subject of discussion. With respect to filling out reports and the stop and the tinted windows, non-tinted windows, etc. The DUI issue with respect to whether the admissions were given properly. And with respect to the matter that we're now discussing, whether the pat-down was legal or illegal. Those are issues that both parties knew at the time that we had the meeting amongst counsel when we were identifying witnesses. So surely both sides knew that they would potentially have to have witnesses regarding those topics. Clearly, the appellant would know that the city's position was that the pat-down was illegal. So obviously, we would know that there would have to be a witness to that being in the city's position. And I'm just curious, because I'm sure I'm going to be asked, and the commission is surely going to want to know why these witnesses, for example, Mr. What's your name, but I don't know, or someone similar would not have been identified as a witness going to be.
Well, I think I answered the question. I think my response is really going to change, but I'll say it in a different way. I asked Lieutenant Vazquez whether, in his view, this vehicle pat-down with the November 5, 2023 incident with Mr. Maldonado, I asked him about the training that officers receive. And he said, he testified to something to the effect of, we don't train officers to do a pat-down search or something to that effect when a suspect gets released. How would I have known that? I mean, rhetorically asking, I know one of the incidents wasn't this. I'm not denying that. But with impeachment witnesses, I think everybody here knows is that I have to be made on notice that someone's going to testify to something inconsistently or in a contradicting way. Vazquez was not interviewed in a case. I did not know what he was going to say. We're measuring these impeachment witnesses against a witness that has already testified. Jason Vazquez was not interviewed by Internal Affairs. He was the investigator. He was not interviewed. I had no idea what he was gonna say until he came up here and put his right hand up and testified. And so after I knew that, I evaluated against whether or not I need to call him. If Mr. Santana testifies and say, look, I think Julian Vazquez was trained properly, which I doubt, if he says that, then I don't need to, then I don't need to call in any impeachment witnesses for this incident.
Do I have any comments, questions from the commission?
I think I have some questions for our council.
Go ahead, please.
I don't know if it should be,
I think those are better addressed.
okay. Closed session.
And before you go, can I just point the commission to a specific exhibit, just so I can bolster my position in my argument for Mr. Maldonado? It's gonna be Exhibit 3, or Exhibit 1, same thing, the notice of intent versus imposition. But the city specifically used the traffic stop on Mr. Maldonado as a basis to fire my client. None of them talked about training here. They just addressed whether or not the justification of pat down was lawful. I'm talking about how officers are trained to do it. That was not contemplated. That was never asked of any witnesses. So when we talk about a contradiction between the testimony of a witness to an impeachment witness, we have to examine whether or not that witness, which is Vazquez, was interviewed about it. He was not. So I hope when you discuss this issue, the inquiries, did we know about what Vazquez was gonna say on the stand before the hearing, which is at the pre-hearing conference? There's no way I would have known that.
Thank you. We'll be off the record. We will recess to closed session. Hello, we will go back on the record. With regard to the witnesses that you've asked the commission to consider, with regard to Chief Dunn, we would like to revisit that issue after Mr. Santana concludes his testimony to see if it's still necessary. Mr. Clark, with regard to Officer Clark, Mr. Bent?
Sure. With respect to what I heard Mr. Yu indicate that the issue is just simply whether Mr. Clark is still employed by the department. If that is part of the testimony, is there a reason the parties can't stipulate to the
I think the other issue is whether or not he was disciplined. I mean, it's two parts of it. The first part is obviously we know he's still employed. So I think the inference you draw from that is he's not fired. But the next inquiry is, was he disciplined for it? Because arguably he and my client committed the same conduct. And I think that's what, to be fair, I think that's what counsel was objecting to, is whether or not he was not asking what kind of discipline. My belief is he was not disciplined at all. And I think Mr. Santana testified last hearing that that in itself, the mistake in itself, rose the level of termination. I did not expect that to come up.
So we will allow Mr. Clark to be added to the witness list. With regards to Lucas Friano, counsel questioned you for the offer of proof, and he's going to review the transcripts and get back to the commission with some of our answers to some of our questions at the next hearing date. With regard to Officer Schmitz, I had cut you short when you were giving me the offer of proof, but I would like to hear it now, and so would the rest of the commission, so if you could proceed with your offer of proof.
Sure. It's actually Sergeant Schmidt. Usually there's not a difference. But
Sorry.
Here there's a huge difference because he's a supervisor. Sergeant Reich Schmidt, first I think I just want to summarize what Lieutenant Fisher has testified. Lieutenant Fisher has testified not to a tolling. In other words, Lieutenant Fisher did not say, hey, we had an exception to the 1 year rule. What he said, what he testified was that when Lieutenant Fisher believed the use of force and the alleged chokehold was viewed by him, Fisher, that Lieutenant Fisher deemed that to be the discovery date. The offer of proof for Sergeant Ryan Schmidt would be that he is a supervisor and he had a duty to open up any kind of investigation to misconduct if he believed that my client did something wrong. And Sergeant Schmidt, as you all know, was not interviewed. Lieutenant Fisher was not interviewed. So Sergeant Schmidt will contradict the 1 year rule as testified by Lieutenant Fisher.
Mr. Bent, can we get
If I could say
Mr.
a
Grather.
couple sentences. Yeah. I do believe that Lieutenant Fisher mentioned something like that. However, I don't recall him testifying anything as to when the statute of limitations would or should have begun running. Regardless, that's not the issue that's in the notice of intent or the letter of findings. It is a tolling issue. It's in black and white, so I don't see the point of adding that. I would just say I don't see the point in adding that testimony. So that's just the city's position.
And if you give me 5 minutes, I will read you what Lieutenant Fisher said, what he believed the statute of limitations, because I asked him a very specific question about when he believed the 1 year rule started. And he testified to something to the words effect of, it's when I, Fisher, saw the video, I believe there was an excessive force or against our force policy on the choking issue. That's when the 1 year rule started. I can read you exactly what he said if you give me a few minutes and I'll pull that up.
Regardless of that, I would just point out that that's not what's in the notice of intent. So either way, it doesn't affect any of the issues that we're dealing with here.
Well, it's not in the notice of intent, but I think I hope council's not saying that they can just do whatever they want. I think the inference is that it is not in the notice of intent because it disfavors the police department. It is not in the notice of intent because if you read the notice of intent date and the incident date, it's more than 1 year. I would imagine it's not in the notice of intent because it would obviously disfavor their position. But I don't want to make this into a back and forth argument, but I will tell you, if you give me a few minutes, I will give you the citation on the night in which Lieutenant Fisher testified exactly to when he believed the statute started. Sergeant Reich Schmidt will tend to contradict that date because Sergeant Schmidt is a sergeant, although he's not a lieutenant. I believe he will testify that if he sees a misconduct, he had a duty on July 28, 2023 to open up an investigation. I believe sergeants are supervisors.
I will just try to make this simple from the city's perspective. The incident with Mr. Garcia occurred on July 28th of 2023. The exception listed in the letter of findings in the notice of intent is that the complainant was charged with a criminal offense which tolls the statute of limitations. He was ultimately pled guilty and had some of the charges dismissed on August 15th of 2023. So therefore that led to the tolling from July 28th to August 15th, therefore making in August 13th, 2024, notice of intent within that 1 year. That's what's listed in the notice of intent and the letter of findings as the reason. So that I will submit on that as the city's position.
So If I'm understanding this correctly, it seems like the issue here is a dispute on the point of law. No?
No.
Excuse me,
If I could recommend, let's have Ms. B, you take the 5 minutes, give us a citation, and then we can compare.
I'll tell you, I have it in front of me, but if I may just respond, you will see no evidence whatsoever that Mr. Garcia filed a complaint. Zero. I'm gonna question Mr. Santana in a few minutes. If you want to table that, we can. I expect Mr. Santana to say there's zero evidence that Garcia made a complaint. I will go through every single one of the complaints in this case. I will give you an offer of proof that there's been no complaint filed by Garcia. Zero. So whatever counsel is telling you, that's what he's telling you. I'm not calling him a liar, but you will see no evidence of Glenford Garcia filing a complaint.
I'm sorry, is the issue a complaint by Mr. Garcia or is the issue a criminal proceeding against Mr. Garcia?
Both.
The-
Yeah, it's in the evidence that he complained he was being choked at the scene. He also told another officer about it.
So, and I'll read you in a very moment. The word complaint and complaining about an injury is very different. What counsel is trying to lead you or mislead you is whether or not a citizen files a complaint. We'll go over that with Mr. Santana in a few minutes. That is not the same as, oh my goodness, I'm being choked. That is a noun versus a verb. Very different. But I'll tell you in Lieutenant Fisher's testimony, I'll cite you to the hearing date of April 13, 2026. Counsel has it. I don't know if he wants to go there, but I'll read you from line 3. From April 13, 2026, I'm at page 36. Question. Let me rephrase that question. When you launched a personnel complaint on 11/25/2023, are you telling this commission that the 1-year timeline started in November of 2023? Answer. My interpretation of the law under the policy is that when I discovered that allegation myself, that was the initiation of the 1-year statute. That was the initiation of the 1-year statute. Continue on line 10. Question. Okay, even though Sergeant Schmitz had already begun his investigation and interviewed witnesses and reviewed reports and reviewed videos in July of 2023, your sworn testimony is that when you reviewed this in November of 2023 is when the statute begun. Is that your testimony? Answer, yes, it hinges on the elements in the law using the word discovery to me indicates awareness. I believe Sergeant Schmitz would say that if he found out that in July 28th of 2023, if my client did something against policy, I believe what Sergeant Schmitz would say and testify to is that Sergeant Schmitz had a duty on that day to initiate a complaint. Nowhere did Lieutenant Fisher ever mention about Garcia filing a complaint or the fact that he's a complainant. Nowhere. You're not going to see that, and I expect Mr. Santana is not going to testify to that.
Now we can address the issues in the one.
We will take a recess. We'll be back. We are back on the record. Thank you for the offer of proof. We considered what you said. The commission feels we have ample evidence to proceed, and we will exclude this witness from testifying. Staff, are there any other administrative matters we need to conclude before continuing to our testimony with Mr. Santana?
Not at this time. As we know, we will revisit witness Robert Dunn following Mr. Santana's testimony, and we will revisit witness Lucas Riono at the July 13th hearing. With that, we can proceed.
Are you prepared to recall witness Danny Santana?
Sort of. It's still Mr. Yu's cross-examination.
I apologize. We have that as where he is your witness, but Mr. Yu will then be the one who is told he may continue at this time.
My apologies. Mr. Yu, you would like to continue your questioning of Mr. Santana?
Thank you.
And Mr. Santana, I will remind you that you are still under oath, having sworn to tell the truth, that that oath is still binding on you, and that you must answer questions truthfully. Do you understand?
I do.
You may continue.
Thank you. Good evening, sir.
Good evening, Mr. Yu.
So we're gonna move on to Mr. Garcia's incident, right? That's the Blimford Garcia. Remember that case?
I do.
All right. I want to jump into what we discussed actually about who is a complainant. Did you believe that, or do you believe that Mr. Garcia filed a personnel complaint against my client?
I believe Mr. Garcia complained about the incident to Sergeant Schmitz.
It's not my question. I'm gonna re-ask it. Okay. You know what a personnel complaint is, correct?
I do.
Let's pull that up. If we could please pull up Exhibit 7, page 82, please. And while she's doing that, you know the difference, while she's pulling that, I'm gonna just ask you some questions, okay?
Yes, sir.
You do know the difference between a personnel complaint versus complaining about an injury, correct?
I believe I do.
Okay. A personnel complaint is when a citizen files a formal complaint alleging some misconduct against a police officer. Is that fair?
It is fair.
And a complaining or the actual verbiage of, hey, I'm injured or stop choking me. That's just somebody saying I got choked or I got hurt, correct?
If it's to an officer, I believe that is someone complaining. Whether that officer went and filled out a form, that's a separate matter.
So to you, as assistant city manager, anytime a citizen says, hey, officer, I'm hurt, or hey, sergeant, this guy choked me, that's a citizen complaint?
Counsel, if I may, that's a compound question, let's break it up.
That wasn't it? All right. Do you believe, sir, there is a difference between a personnel complaint versus somebody just complaining about an injury?
Yes, I do believe there is a difference.
Okay. And whenever you're ready, Ms. Coleman.
Yes, to confirm that's page 82.
Exhibit 7, page 82. It is not, but let me just direct you to. Exhibit 7 is Mr. Garcia's incident, and page 82 should be a City of Torrance personnel complaint. And the complainant is the person that's filing the complaint to you. Is that right?
To an officer, correct?
Let me re-ask the question.
Okay.
A complainant in a personnel complaint is the person filing the complaint, correct?
Yes.
Mr. Chief, to come back, Exhibit 7 is the digital only department exhibit. That only has one document in the file, PD 2023-009, but that does not appear to be the correct document. Is that right?
Could I show you what I have? I'm sorry.
If we could take a brief recess.
Yes, we're off the record.
No, I think it's the issue on. Because as I told you, she's also giving me it, there's an arrow.
Oh, no problem.
No, sorry. And then I apologize that that's where you're doing this. And the online version is a little more difficult nowadays. So like, Chair Liz, I am ready to come back on the record.
We are back on the record.
All right, and I'm showing you Exhibit 7, PG2. Do you see that in front of you, sir?
I do.
Okay, and this is the personnel complaint filed against my client, correct?
Yes.
And the name complainant is Lieutenant C. Fisher, correct?
That is what is listed, correct?
It does not say Glenford Garcia, right?
That is correct.
And the date doesn't say July 28, 2023, correct?
That is correct.
Tell the commission what the date was.
November 25th, 2023.
Okay. And then if we could scroll down, please, Ms. Cohen. Now, this is the only personnel complaint form for a complainant, correct? For the city of Torrance.
I do not know.
You don't know whether or not if there's any other form of personnel complaint?
That is correct. I do not know.
Okay. If you could scroll down just a little bit more. There you go. Okay, second page. Okay. And it says person receiving the complaint. You see that?
I do.
To you, does that mean person taking the complaint?
It does.
All right. And it says Lieutenant Chance, correct?
It does.
Michael Chance?
Yes.
All right. Doesn't say Schmidt or anybody else from July 28, 2020, correct?
That is correct.
And the date that the complaint was taken was November 25, 2023, right?
Yes, sir.
Okay. And I just want to contrast this personnel complaint with some of the other cases, okay?
Yes, sir.
When you reviewed other cases where a complainant filed a complaint, you know that those individuals signed what has their name on the complaint, correct?
That is correct.
Let's show the commission some of them. Let's go to Exhibit 10, page 27 out of 80 in the PDF document. The document, I think it's the only PDF document, is P2023-046.
Yes, an 80-page document.
Yes, ma'am. And I would like to go to page 27. All right, I'm showing you Exhibit 10, page 27 out of 80. Do you see that on the screen, sir?
I do.
That's that is the same personnel complaint form you saw earlier, correct? In Garcia's case.
That is correct.
All right, in this case, what I'm showing you right now is the Wimberley case captioned P2023-046, correct?
Yes, sir.
And to you, when you're reviewing this document, did you take it that Ms. Kimberly filed this on her own?
Yes.
It's in handwriting, correct?
It is in Henry.
Okay, and it has her last name, Kimberly, right?
Wimberley?
I'm sorry, Wimberley.
Yes.
And with Ms. Wimberley, to you, Ms. Wimberley came to the station and filed a complaint. Is that your understanding?
My recollection from the record is that she came to the station, attempted to file the complaint. The sergeant wasn't available. I believe she spoke to an appropriate TPD personnel call. TPD personnel following.
And that happened after Ms. Wimberley spoke to the additional personnel. At any event, at some point in time, Ms. Wimberley came to the station and wrote this complaint herself. Is that your understanding?
My understanding is that she filed it. I don't know if she wrote it herself or it was filled out.
Fair enough. And Ms. Cohn, if you could just scroll down a little bit, please. All right. And where it says signature, let's go to person receiving complaint. You see J. Gonzalez?
I do, sir.
Did you take that as Officer Gonzalez?
Yes.
And then there's a signature of complaint. Did you take it that Ms. Wimberley signed this?
I don't see the signature of the complainant.
Oh.
My apologies. I didn't know what her signature looks like. I can't tell if that looks like Wimberley. I didn't know who signed it.
Well, to you, if Ms. Wimberley filed the complaint, did you understand it that Ms. Wimberley was the one that signed it?
Not necessarily, sir.
Okay. Next page, please. All right, stop right there. Did you see the word Wimberley, 11/29/2023?
Yes.
Who do you think wrote this word Wimberley, 11/29/2023?
I don't know who wrote that on the top. My recollection of this document was this was Ms. Wimberley's words about her experience with Officer Vazquez.
All right.
I don't know who wrote on the top.
Fair enough. Did you ask whether or not Wimberley was the one that signed it?
I did not.
When you're reviewing this case, did you take it to mean that Wimberley was a complainant?
Yes, I did.
All right. We can close this. If we can please go to Exhibit 12. Digital exhibit only, Exhibit 12. The document name is complaint form.
Yes, that is a two-page document.
Yes, ma'am.
Would you like to start with page one?
Page 1, thank you. I'm showing you, sir, Exhibit 12, complaint form. And this is the two-page document. Do you see that in front of you?
I do.
You reviewed this document as part of your decision to fire my client?
I did.
All right. Personnel complaint, correct? City of Torrance Police Department?
Yes, sir.
And it says Correa.
It does.
Did you take it to mean that Mr. Correa was the complainant?
Yes,
Does not say Chance or Fisher, right?
that's correct.
Let's go to the next one, Exhibit 9. In Exhibit 9, there is two documents, and I'd like to go to the PD 2023, let's see, 2023-044 with redactions, please. It's a 103-page document. If you can go to page 27, please. All right.
You need a page here, Mr. Chief.
Yes, sir. 27 out of 103. Okay. You see page 27 out of 103 in Exhibit 9?
I do.
You reviewed this document also in your evaluation to terminate my client?
I did.
This is another City of Torrance Police Department personnel complaint, correct?
Yes.
All right. The complainant is Mr. Personnel, correct?
Yes.
The complainant is not Fisher or Chance or any lieutenant, correct?
Yes.
Did you take it to mean that personnel filed a complaint against Officer Vazquez?
Yes.
So I showed you 3 separate incidents aside from Garcia's where somebody filed a complaint against my client, correct?
You did.
And you would agree with me, in Garcia's incident is the only incident in where Mr. Garcia did not himself file the complaint, correct?
Objection is vague and ambiguous.
I have a question with that.
And you would agree with me in Garcia's incident is the only incident where Mr. Garcia did not himself file a complaint, correct?
Well, the objection is simply witness understands it, but you don't tell us.
You may answer.
Correct, Mr. Chief.
So, and by the way, in all the incidents that we're here for, the only cases in which a citizen filed a complaint are the ones I just showed you, correct?
That is my memory, yes.
Wimberley, correct?
Yes.
Carrera,
Yes.
and Presnell.
Yes.
And then according to you, somehow Garcia complained about an injury, but was not the person that filed a complaint. Is that accurate?
Objection, argumentative and compound.
It's a single objection.
Sure.
Sustained.
I'll take you through a different way, sir. When you reviewed this case, you understand that the date of incident occurred on July 28, 2023, correct?
Yes, sir.
All right. And you would agree with me that Sergeant Schmitz wrote a report summarizing his review of the incident. Is that fair?
That is fair.
To you, is Sergeant Schmitz a supervisor of the Torrance Police Department?
Yes.
You would have expected him, or you would expect him, to report any kind of misconduct if he saw something, correct?
Yes.
He's a mandated reporter, correct?
Objection is vague and ambiguous as to that term. Mandated reporter.
I was just saying objection.
There's probably, I'll ask a different way.
No disrespect.
None taken. I'm human. To you, sir, as Assistant City Manager, would you expect, or do you expect, your sergeants to report misconduct?
Yes.
You're not telling this commission that a sergeant can observe misconduct and then walk away and do nothing.
Not sure I understand your question, sir.
Sergeants are charged to report misconduct if they see something against policy or law. True?
True.
And sergeants are also charged to initiate an investigation if they see something against policy or the law, correct?
Correct.
Now, you cited some terminology I want to take you through. If you can please go to Exhibit 1, page 8 of 26.
Yes, sir.
All right. Just want to make sure everyone's there. All right. Do you see where it says Garcia's complaint?
Yes.
All right. And you wrote Sergeant Schmidt arrived on scene and spoke to Garcia, who complained of pain to his throat, prompting Schmidt to request a medical evaluation from the Torrance Fire Department. See that?
I do.
Nowhere did you say that Garcia filed a formal complaint, correct?
No.
Garcia was describing an injury. He was complaining that he was hurt, correct?
Yes.
Nowhere did he go into the station and write what we just saw on Carrera, Wimberley, and personnel, correct?
Correct.
Garcia never went back to the station and filled out a form that we just saw on the screen, correct?
Correct.
And by the way, in the investigation concerning Mr. Carrera and personnel and Wimberley, at least for Wimberley and personnel, they were interviewed, right, by internal affairs.
Yes.
And Carrera, to be fair, he was represented by counsel, so internal affairs didn't interview, correct?
I'm sorry, so internal affairs business?
Bless you. Carrera was represented by counsel, correct?
That's my understanding.
Garcia was never attempted, to your review of this file, never was interviewed by anyone from Torrance PD's internal affairs, correct?
Incorrect.
You reviewed documents in where Mr. Garcia was interviewed.
Yes.
Garcia was interviewed by investigators from Torrance PD
Yes.
on a recorded interview.
I don't know if it was recorded.
Do you expect an unrecorded interview of a complainant filed against a Torrance police officer?
Mr. Yu, I don't conduct the investigations. I don't know if it was recorded. I wouldn't want to spend.
Not my question. As an assistant city manager, do you expect internal affairs to record all interviews that they conduct? Yes or no?
Objection is asked and answered.
You can answer the question.
Yes.
Because that is the way in where truth is being sought, correct?
Yes.
You want to make sure whatever the investigators are asking is being digitally recorded so we can have a record of it, correct?
Yes.
Just like all witnesses in an interview, correct?
Yes.
Just like my client, when he was interviewed, it was all recorded, correct?
Yes.
Just like we have a court reporter here taking down your sworn testimony, true?
True.
My question is, as you stand here tonight, are you telling this commission that you reviewed transcripts of Mr. Garcia's interview?
Objection is asked and answered.
Was there a question that was asked of you, Mr. Santana?
Yes.
I'll sustain the objection.
Let's go to Exhibit 7, please.
Yes, which page number?
Well, we're going to start from the top because I want to make sure it's on page 1. All right, showing you page 1 out of a 284-page document. You see that in front of you?
Yes.
You reviewed this document as part of your evaluation to terminate Officer Vazquez.
I did.
It says table of contents, correct?
Yes.
Case summary. Did that contain Mr. Garcia's recorded interview?
Objection is vague and ambiguous and assumes facts.
I'll ask it a different way. Case summary. did you read any kind of statements from Mr. Garcia in where it says case summary?
You mean on page 1, Ms. Yu? Or do you mean in the entire 280 some odd page document?
Anywhere in the universe of documents reviewed, I presume it's in the 84 pages, correct?
Yes.
Are there any documents that you reviewed, sir, and we can go through each page, that is not in the 284 page document?
Not that I can recall.
Okay, so I don't want to go through 284 pages, but I will if I need to, okay? I'm asking you for the case summary, because this is the table of contents, correct?
Yes.
Okay. Do you recall reading Mr. Garcia's statements in the case summary?
In this file, yes.
Okay. I'm going to go down to the case summary, and I want you to tell the commission where the statements are. Please go to page 2. And if it's easier, I can show the witness a paper copy so I don't have to have Ms. Cohen read or go through the pages. If the commission will allow me to just give the witness a paper copy of this exhibit.
I think you might want to show it, because I don't think the commissioners have.
Oh, okay, then,
To confirm, the commissioners do have a hard copy as requested for Exhibit 7 specifically, not all electronic exhibits, but as Exhibit 7 has been referred to frequently, the commission does have a hard copy as well.
all right, well, let's go through it and see if Mr. Santana can answer my question. If you can go to page 2.
To confirm, Chair Lonis, is the commission agreeable to Mr. Santana doing this via paper copy as well as the commission following along via paper copy?
Yes.
Is that the commission's copy or the
It
witness?
is.
If I may, we could go to page 23 and that might save us some time. But I'll allow Mr. Yu to question as he sees fit. Of course, you'll allow it. I'm not.
Why don't you go to page 23, sir, as counsel suggested, and I'll ask you some questions, okay?
What page, I'm sorry, 22 or 23?
23.
Yes, sir, I'm on page 23.
All right. Can we publish page 23? Okay. I think you have to go up just a little bit. I'm going down a little bit. It says interview with Mr. Garcia Jr.
If I may, it has page 22 on the top right corner, but it is the 23rd page of the PDF.
Thank you, Mr. Greco.
You're very helpful tonight. Right there. Thank you very much, sir. All right. Could you just go down a little bit where it says interview with Mr. Garcia? Okay, stop right there. Okay. This is not a transcript, correct?
That is correct.
You know what I mean by a transcript, sir?
I misunderstood your question. My
Okay.
apologies.
Well, I want to make sure you understand what I'm saying, so I guess we'll just do it another way, and I hate to do this, Ms. Cohen. Could you please go to, could you please go to Exhibit 10? And page 41. It's an 80-page document where it says complainant Wimberley transcripts. Okay, do you see where it's being published?
I do, sir.
Tell the commission what it says.
Objection if document speaks for itself.
Sustained.
Complainant Wimberley transcript, is that what you read?
I do.
Okay, transcript meaning it's a recorded interview, correct?
Correct.
And complainant to you means Ms. Wimberly filed the complaint?
Yes.
Okay, if you could scroll down to page 42. Okay. Sergeant Vazquez asked the question, thank you for calling me back, Ms. Wimberly. Hey, how are you? Question mark. Do you see that?
I do.
To you, this is a recorded phone call, correct?
Yes.
Where Vazquez was doing the investigation on Wimberly?
Yes.
And to you, was it because Wimberly filed a complaint
Yes.
and it was recorded, right?
Yes.
Okay. Let's go back to Garcia's incident. Did you read anything like in Wimberly's case where there was an interview transcribed by Sergeant Kronbach?
No.
All right. We're still on Garcia's case. I want to move to a different subject on Garcia's case, and I believe, and I want to address some of these alleged chokeholds that you wrote in the letter of finding. Okay.
Yes.
All right. You've never attended a use of force class of any kind. Is that true?
Correct.
You've never, I think you testified in the last commission meeting that you were never a police officer, never had any kind of formal training whatsoever, correct?
Objection as vague and ambiguous and mischaracterizes testimony.
Can I have a question on that, please?
You've never, I think you testified in the last commission meeting that you were never a police officer, never had any kind of formal training whatsoever, correct?
It's compound, I don't know.
Overruled.
Correct.
And you know that, you know who Sergeant Wells is from the Torrance PD?
I don't know him personally.
Do you know that Sergeant Wells?
Yes.
Okay, let me just ask my question, okay? You understand that Sergeant Wells is a sergeant employed by the Torrance PD?
Yes.
And you understand that Sergeant Wells, at least during this time period in July of 2023, is recognized to be the department's use of force expert?
Yes.
And I believe you indicated that the decision to, your decision was that the Garcia incident and the alleged chokehold was unreasonable, correct?
Unreasonable use of force.
Correct.
Yes.
Okay, so you disagree with Sergeant Wells' finding that it was a reasonable response by Officer Vazquez being kicked in the groin, correct?
Yes.
Tell the commission what you're basing it on.
Objection as it's vague and ambiguous.
You know, I'll ask it a different way. Did you base your finding on your own use of force training?
No.
Did you base your finding on your own use of force experience?
No.
Did you base your finding on your own use of force tenure?
No.
Did you find the use of the unreasonableness based on your own use of force reading of the police practices and protocols and procedures?
Objection as compound and vague and ambiguous.
I have a question on that, please.
You're going to use the unreasonableness based on your own use of force reading of the policies and practices and protocols and procedures. motion is based on the own use of reading of the police practices and protocols and procedures.
Let me read from the top one more time, I'm sorry.
Did you find to use the unreasonableness based on your own use of force reading of the police practices and protocols and procedures?
Any objection?
Compound and ambiguous.
My recommendation is
Overruled.
It was partially on that.
You read materials of police procedures.
What was included in the notice of intent? Yes.
Did you read any kind of materials on police training on the use of force topic?
No.
For instance, do you know what the peace officer standards and training is?
I don't know it in detail.
Okay, you know what a learning domain is?
I do not.
You know what officers will recruit officers when they get trained in the academy, they have learning domains, chapters.
No,
You know what learning domain 20 is?
I do not.
You know what learning domain 37 is?
Objection argumentative. And irrelevant, asked and answered.
I think he's made it clear that he does not understand or is not familiar with the post standards that you're citing here.
That was a very broad question, but I'm asking specifically learning domain 20 is a use of force learning domain. Some people may not know the post standards on other learning domains, but they can know, for instance, patrol techniques, patrol operations. So yes or no?
Mr. Santana, are you familiar at all with the post standards document that's some chapters that he's referring to?
I am not.
If you could move on, Mr. Yu.
Have you reviewed any kind of other police training or materials on use of force?
No.
I'm going to ask you some questions about the Torrance PD policy. That you know, correct?
I don't know it by memory, but I did review it as a part of this review.
Sure. And I'm not testing you on word for word, but generally speaking, you agree with me that the policy of Torrance PD does not prohibit all contact with the suspect's neck.
Yes.
The policy of TPD only prohibits direct pressure on the trachea or windpipe, correct?
I believe there's more to that policy section, but your statement is contained within it.
So yes to my question?
Yes.
Can we agree that the best way and the certain way to find out whether or not a direct pressure was applied is to ask the person who is alleged to have been choked?
Yes.
When you reviewed that page number, I think was 21 that council pointed, interview of Garcia, you agree with me that nowhere in that paragraph contained any kind of evidence that was asked by Kronbach to Garcia about whether or not there was direct pressure on his neck, correct?
Objection is a document speaks for itself.
I was just saying that objection.
Sustained.
Can we pull up Exhibit 7, please?
Yes, which page?
I think it's 23 that council pointed, or 21. Let me pull that up. 23. All right. Interview of Mr. Garcia. You see that?
Yes.
You reviewed this document?
Yes.
In this document, do you recall any kind of questions concerning whether or not Garcia had direct pressure applied to his trachea windpipe?
I believe on the next page, there was an exchange between the internal affairs and Mr. Garcia that does speak to pressure being put on the windpipe.
My question is very, very specific, okay, sir? My question is, when you read this portion of the document, do you remember Sergeant Kronbach asking Mr. Garcia whether or not there's direct pressure applied by my client to his trachea or windpipe?
Yes.
Which portion of the document are you referring to, sir?
You go to the next page, I believe it's the third paragraph. Right there, internal affairs asked Mr. Garcia when he was placed in the back of the patrol vehicle if anything happened. Mr. Garcia said no. Internal affairs asked Mr. Garcia a follow-up question if he was choked by an officer while being placed in the back of the car. Mr. Garcia responded, I believe so. When asked to describe in more detail what occurred, Mr. Garcia said he was thrown into the vehicle and during the time he was grabbed by his neck and thrown into the car like a dog.
My question is very specific, sir. Do you remember reading any document concerning the question of whether or not Garcia had direct pressure applied to his trachea windpipe?
Yes, it's in the next paragraph. Therefore, internal affairs asked if he lost any breath if his windpipe was affected to it. Yes, internal affairs asked Mr. Garcia about the specifics of the choke, to which he initially didn't provide any further detail. Therefore, internal affairs asked him if he lost any breath or if his windpipe was affected, to which Mr. Garcia responded, for sure. Internal affairs asked Mr. Garcia again to elaborate on his memory of any physical ailments he suffered as a result of being choked, but Mr. Garcia did not provide any further detail.
Let me turn you, sir, to the policy of the use of force that you cited, okay?
Yes.
Can you go to Exhibit 1, page 3, sir?
Mr. Yu, to clarify, is that 3 of 26?
Yes, sir, and I'm pointing you to number 5.
Yes, sir, I am there.
A chokehold means any defensive tactic or force option in which direct pressure is applied to a person's trachea windpipe, correct?
Yes.
Was the question, well, number 1, we know this is not recorded, correct?
That is correct.
It is the only interview, out of all the interviews, they're not recorded, correct?
Mr. Yu, this is redundant at this point. We know it wasn't. I mean, he testified repeatedly to that question.
Agreed. I'm just setting the foundation for how this witness knows the word choke. Just,
Actually, was.
sure. Can you point me to the question that was asked, whether or not Garcia suffered direct pressure to his trachea or windpipe?
I can't point you to that question.
But that's the basis of violation of policy, correct?
That would be correct.
Now, I just want to get some dates in. My client was relieved of duty, placed on administrative leave on November 25, 2023. Does that sound familiar to you, sir?
It sounds familiar.
Okay. I calculated it's exactly 120 days, 3 months and 28 days. I don't think people would disagree. My question is, did you find out or ask anyone why Julian Vazquez was allowed to be on full duty for 120 days if he violated the law or policy? from this incident?
I did not.
Did you ask yourself or anyone else, the city attorney or the prosecutor, if this alleged repeated choke by Julian Vazquez was excessive? Why Julian Vazquez was a victim of a crime that was prosecuted by the DA's office?
To object as a compound and vague and ambiguous, which may also call for attorney-client privilege.
Question with that, please.
Did you ask yourself or anyone else, the city attorney or the prosecutor, if this alleged repeated choke by Julian Vazquez was excessive, why Julian Vazquez was the victim of the crime that was prosecuted by the DA's office?
It is compound.
Sure. Why don't you go to, sir, Exhibit 1, page 9.
Yes, sir.
Do you see count 4 on there?
I do.
It says criminal investigation and prosecution. Do you see that?
Yes, sir.
Okay. You see count 4?
I do.
243B of the Penal Code, willful and unlawful use of force against Officer Vazquez. Do you see that?
I do.
You took it to mean that Garcia was charged for the willful and unlawful use of force against Vazquez?
Yes.
Okay. My question to you is, you wrote this section in here, correct?
Correct.
When you wrote this section in here, did you ask yourself, outside of any attorneys, hey, if Julian Vazquez was the victim of a crime, how can we say this is a repeated chokehold against the law or policy?
I did not.
Out of all the years that you've worked for the city of Torrance or anywhere else in your public service, had you ever seen an incident in where an officer was fired for an incident, but he's also a victim from the same incident?
I have not.
You understand that initially Lieutenant Charles Fisher believed that this incident arising from Mr. Garcia was a violation of policy. He wrote a complaint about it, correct?
Yes.
Ultimately, you understand that Lieutenant Fisher recommended training, not termination, but training for Officer Vazquez, correct?
I don't recall that.
Okay. Can we go to Exhibit 7, page 168? Or is this as a result? Do you see that? I've drafted a personnel complaint related to the above listed violation. I also recommend that Officer Vazquez receive remedial use of force training at the next available opportunity. You see that?
I do.
You disagree with Lieutenant Fisher, correct?
I do.
And you also disagree with Sergeant Schmitz, correct?
Correct.
And you also disagree with Sergeant Wells, correct?
Correct.
I'm going to switch gears a little bit, sir. I'm going to ask you about the personnel incident, which is the field interview card, okay?
Yes, sir.
Do you have that in mind, sir? Do you have that incident in mind?
I do.
And to you, that incident was not the incident that you would have recommended or imposed termination for, correct?
That is correct.
In other words, you don't turn in a field interview card. It's by itself is not termination, right?
For me, that's correct
Okay.
in this instance.
Well, how about, have you ever recommended or imposed termination in any other incidents for failure to turn in a field interview card?
I have not.
Okay, I don't know if we want to take a break. I'm going to go into another incident that's going to be pretty lengthy.
Okay, yeah, let's take a break and come back at 9:05. Yeah, 9:05. Thank you.
9:05?
Yeah.
Okay.
We're off the record. Mr. Yu may continue.
Thank you very much. Sir, I think I forgot to ask you this in the beginning. Last hearing night, you testified that you reviewed, as part of your duties as the Skelly officer, you reviewed my client's personnel file, correct?
Yes.
And I think you testified, correct me if I'm wrong, that is a mandatory duty by you just to review an officer's personnel file to see who they are, correct?
It is my duty under policy 39.
Correct. And the personnel file, just so I get an understanding, they consist, for instance, your name, correct? Date of birth, address, next of kin information, like a biographical information, correct?
Correct.
And then also contains, for instance, performance evaluations,
Correct.
Start date, end date,
Correct.
commendations if they have any,
Yes.
complaints, correct?
Yes.
And investigations.
Yes.
Okay, and those are the documents you reviewed, correct?
Yes.
All right. In this instance, I'm going to move on to the Mr. Maldonado's incident. That's the traffic stop with the vehicle pat-down search. You have that in mind, sir?
Yes.
Okay. And you reviewed, I know it's been a while, but you reviewed the file and report containing the Maldonado investigation, correct?
Correct.
And to you, that investigation by itself would necessarily warrant termination, correct? Would.
Correct.
In other words, just so we get a clear record of it, the Maldonado incident for the vehicle pat down by itself would have gotten Julian Vazquez fired for that sole incident, correct?
Correct.
And I think you cited several policy violations along with just the, I'll ask it a different way. When you reviewed the vehicle pat down, did you take it to mean that my client violated Mr. Maldonado's rights under the law?
Yes.
Essentially, do you believe that Officer Vazquez exemplified or not exemplified the Torrance PD's core values?
Did not.
How about did his actions using thwarted or prevented an armed robbery nearby the mall?
Sorry, can you restate that?
Sure. Do you believe when you're evaluating the incident involving Mr. Maldonado, did you believe that Julian Vazquez potentially prevented an armed robbery?
It was a potential.
Did you believe that the stop and arrest of Mr. Maldonado was a great example of proactive policing?
The stop? Yes. Proactive policing.
How about the arrest?
No.
So the arrest itself did not provide a great example of proactive policing, correct?
Correct.
Did you believe that Julian Vazquez violated policies?
Yes.
Were you aware, sir, that Julian Vasquez received a comment card praising his arrest by his supervisor? Did you read that in the personnel file?
I don't recall that.
Could we mark? I think we're on Exhibit E now, which is the next in order.
You said E, right?
E as in Edward. Is that the next in order?
I believe that may have been used. I am cross-referencing the file. Mr. Yu, on April 13th, you have provided me exhibits F and G.
Oh, I'm way off.
Although not all of these exhibits have been admitted, I'm not sure if you want to go further down out of an abundance of caution, so there's not confusion on the lettering.
No problem. We'll just mark it as next in order. I don't know if
Would
the
be H.
H. And I know the,
Ms. Cohen, just for confusion, some clarity, we have exhibits A through C in our binders. I don't have some of the exhibits that are referring to. Are these in evidence or are they going to be provided at some later date? What's going on?
Not all have been admitted into evidence, not all have even been offered at this point to be reviewed. Some, such as exhibit, I believe D, has been a demonstrative exhibit. But that is something that we will take care of to ultimately determine for these demonstrative exhibits if they will be admitted fully as exhibits for the file, and we will clarify with exhibit letters used but not admitted once we get to that time in the hearing.
in,
Determine if they will or will not be.
Thank you.
all right. So we're gonna identify this exhibit as an H. I just emailed counsel and Ms. Cohen the exhibit along with Mr. Bent. If you could publish the exhibit for identification H as in Henry
You're identifying as what exhibit H is.
is part of my client's personnel file. It's a one-page document. Evaluation.
Comment card?
Yes, sir. And you know what an evaluation comment card is, correct, sir?
Yes,
You've reviewed them in personnel files in the past.
correct.
That is a praise, a commendation to say you did a good job. Is that fair?
It is.
And as this is a new exhibit, I will look to Mr. Grecker to determine if there is any objection from the department.
The department would, just note it hadn't been offered when it was supposed to be, but there's no objection to this. To H, anyway.
And while she's doing that, sir, I'll represent to you that in Maldonado's incident, the last four number of the report number is 1975. Any reason for you to dispute that, sir?
No, sir.
And to clarify, this is being pulled up for the commission's review. This has not been admitted into evidence, as the commission would be the determining body if an exhibit provided following the pre-hearing conference is or is not admitted into evidence. But this is the ability for the commission to visually see this document as it is only electronic at this point.
Well, I'll ask you this way, sir. Showing you Exhibit H, about to show you Exhibit H. All right. You reviewed this evaluation comment card as part of my client's personnel file, correct?
Can I please read it briefly, just to jog my memory?
Absolutely, sir.
Ms. Cohen or Mr. Barrow, can you scroll down? Yes.
This would have been something you reviewed as part of your duty that you just testified to, correct?
Correct.
That's part of my client's personnel file, right?
Yes.
Okay. Can we scroll up a little bit? And this comment card has to do with the same incident as the Maldonado incident where you, correct?
That's correct.
Where you testified to this commission a few minutes ago that you would have fired my client for, correct?
That is correct.
All right. And the DR number is the report number, to your understanding, sir?
Yes.
Incident 1975?
Yes.
Okay. And the first paragraph gives a synopsis, correct, of the incident, right?
Yes.
And it says on 5 November 2023 at approximately 15:41 hours, Officer Jay Vazquez was proactively patrolling the area of Del Amo Fashion Center. Right? Did I read correctly?
You did.
He observed a vehicle maneuvering through the streets with multiple CVC violations, correct?
Yes.
And CVC is the California Vehicle Code.
Yes.
It was clear the driver had seen Officer Vazquez and attempted to evade him by quickly entering into the Nordstrom parking lot. Did I read it correctly?
You did.
Officer Vazquez therefore initiated a traffic stop in front of Nordstrom's, right?
Yes.
Officer Vazquez quickly noticed a bullet hole in the rear of the vehicle and observed several furtive movements by the driver. Correct?
Yes.
Assisting officers arrived on scene, and the investigation that followed revealed that the sole occupant was in possession of a handgun, ammunition, various forms of suspected narcotics, a ski mask, gloves, zip ties, and items consistent with robbery activity. Did I read it correctly?
You did.
The driver was eventually arrested for probable cause robbery, 11370.1 AHS. Do you know what that means, sir?
I do not.
Does the possession of a firearm with narcotics sound familiar to you? 11370.1?
The possession of the firearms and narcotics, that sounds familiar, but not the section that you're quoting.
How about
that
can
I
it-
don't know.
No problem. Along with additional charges, weapons charges. It was also discovered that the driver had been shot at during a recent Harbor City area shooting. The next paragraph. By the way, this was written by Sergeant Kim, correct?
If you could scroll down. Yes,
And you know Sergeant Kim is a sergeant with Torrance PD
that's correct.
that was supervising my client.
Yes.
The next paragraph. Officer Vazquez exemplified the Torrance Police Department's core values of service and pride during his shift. Did I read correctly?
You did.
What did you take that to mean when you reviewed this piece of document? That Officer Vazquez exemplified the Torrance Police Department's core values of service and pride during his shift.
That Sergeant Kim felt that Officer Vazquez was being proactive and did a good job on this instance.
You disagree.
I did.
Officer Vasquez's action likely thwarted an armed robbery at the mall or nearby. This traffic stop and arrest was a great example of proactive policing. Officer Vasquez's work ethic shows a dissatisfaction with the status quo as well as an enhanced service to the community. Did I read it correctly?
You did.
What did you take that last line to mean?
Objection at this point. The document speaks for itself.
Sustained.
When you read this document, what did you think when Sergeant Kim wrote this? What was your reaction reading the document?
Objection is asked and answered.
Sustained.
In fact, this was Officer Vasquez's second arrest for illegal firearm possession in 2 days. Another one of Officer Vasquez's proactive stops the day prior led to an arrest for firearms and warrants. It has the report number, correct?
It does.
Did you inquire as to that case and the report number?
I did not.
Officer Vasquez is commended for his dedication in keeping the city of Torrance safe. Do you disagree with that?
I don't.
And by the way, November 12, 2023 was 7 days after the arrest of Mr. Maldonado, correct?
Can you say that again, Mr. G?
Sure. Mr. Maldonado's arrest happened on November 5, 2023, correct?
That's my recollection.
So November 12 would be several days after.
That's
a
right.
week after.
Yes, sir.
And at this time, you understand that Mr. Maldonado's case had already been reviewed and rejected for charges filed by the DA's office, correct?
No, I don't recall that.
All right. Did you ask or did you cause anyone from Torrance PD to interview Sergeant Kim?
No.
Did you ask yourself, hey, if Sergeant Kim is commending Vasquez for this arrest, why am I firing him for this incident?
I did not ask myself that.
Did it concern you as the assistant city manager that a supervisor commended Vasquez for this arrest and this incident, and yet you're firing him for this incident?
It did not, because Sergeant Kim may not have had the information from the city attorney's office or the prosecutor.
And you don't know that because Kim was never interviewed, correct?
That is correct.
You're speculating.
I'm giving you my yes.
And you certainly reviewed the investigation file concerning Mr. Maldonado's incident.
Yes.
I know you don't have any formal training in use of force. I don't want to assume or speculate. So I'll ask you this. Do you have any experience in reviewing search and seizure and the laws of arrest concerning police procedures?
I do not.
You reviewed the investigation report concerning this incident authored by then Sergeant Jason Vazquez, correct?
Yes.
All right. And you reviewed the documents in which Sergeant Vazquez attached as part of his investigation packet?
Yes.
Can we please pull up Exhibit 8, please? Now, in Exhibit 8, there is one PDF document under court cases, and it ends in 1975. And while this exhibit is being pulled up, you understand that the core issue in this incident was whether or not Officer Vasquez was justified
in conducting a limited pat down in the area in which Mr. Maldonado had access to, correct?
Yes.
You understand that Officer Vasquez was not doing a full search of the vehicle, correct?
Yes.
Or at least to be fair, the full search of vehicle was not conducted after the discovery of the pistol, correct?
Yes.
And you understand that Officer Vasquez was conducting this limited pat down to ensure that there's not a gun nearby Mr. Maldonado's reach. Was that your understanding?
Yes.
And that, according to you, was against policy, correct?
Yes.
That to you was against the law of our country in the Fourth Amendment jurisprudence. Is that right?
Object. The document notices the letter of finding speaks for itself, and there's, I don't believe there's anything about the First Amendment there. Calls for legal conclusion.
I can't hear counsel by his objections.
I'm sorry, Mr. Yu, what did you say?
I couldn't hear counsel.
He said it calls for a legal conclusion, and I would agree with that, Sustain.
Mr. Yu, for the document, that's a 66-page document.
Yes, ma'am.
Which page number would you like?
Well, just give me 1 second. I'm gonna direct the witness to Exhibit 1, page 17. And just on page 18, I just want to refer the witness to a very specific point, and I'll ask you to pull the exhibit.
Sorry, Mr. Yu, 17 or 18?
It's exhibit 1, sorry, page 18 of 26.
I am there, sir.
Okay, just want to give commissioners an opportunity to get there.
I'm sorry, which page?
Page 18 of 26, and I'm on the third paragraph, and I am right above where it says E, November 24th, 2023 traffic stop. I'm one paragraph above that. Are you there, Mr. Santana?
Yes, I am,
Okay.
sir.
Do you see where you wrote, the city prosecutor disagreed and rejected the case due to an unlawful search?
Yes, sir.
That unlawful search to you was because it violated the law, correct?
Yes.
The law of our country, the Fourth Amendment law?
I do not know which specific law.
So you just wrote, the city prosecutor disagreed and rejected the case due to an unlawful search.
Yes.
What makes an unlawful search?
My understanding was it did not meet the requirements for a vehicle pat down because the suspect had already been removed from the vehicle, had been detained, sat on a curb at a distance from the vehicle, was being watched by another officer. And the officer had called for a code 4 on this specific instance.
And you understand, or do you understand at some point that if Mr. Maldonado was going to be released, that Mr. Maldonado would have to go back to his vehicle?
Yes.
And did you believe that it was unlawful to you for the officers to do a limited pat down the car for their safety?
No.
So it was not unlawful, meaning they were allowed to you at least to perform a limited search just to see whether or not a gun was there, correct?
No, what I'm saying is it did not meet the criteria for the vehicle pat down.
Okay. And you certainly read the documents that Sergeant Vazquez attached, correct?
Yes.
He attached some case laws, not to have you make any legal conclusion, but you read the portion of the case law that Vazquez attached, correct?
Yes.
You understand that part of what he attached was a United States Supreme Court opinion, correct?
Yes.
The United States Supreme Court is the highest court of this land, correct?
It is.
And do you remember, as you stand here tonight, that one of the documents Sergeant Vazquez attached was an opinion about conducting a limited pat-down of a vehicle when the suspect is detained but about to be released back to the car?
Yes, I believe that was Michigan v. Long, or Long v. Michigan, one of the two.
Outstanding. You remember reading that?
I remember reading.
And you remember reading in Michigan versus Long, where the court says that it was reasonable for officers to conduct a limited search of the suspect's car because they're about to be released back to that car.
When it met certain criteria. When it met certain criteria.
Do you remember reading the document where the Supreme Court says a protective search of the passenger compartment of the car was reasonable because the court, wanted officers to ensure their safety and not release a suspect to the car where a gun might be there?
I don't recall it to that detail.
Do you disagree with that principle?
You're asking for a legal conclusion?
No, I'm just asking him in his, I'll rephrase that question. As a assistant city manager, do you expect Torrance police officers, when they have a suspect detained outside the car, do you expect them not to conduct a limited pat down the car to make sure a gun is not used to shoot and kill them?
Just an objection as it's an incomplete hypothetical, it's vague and ambiguous.
I was sustained those questions.
Sustained.
In this case, you understood that Julian conducted a limited pat-down search of suspect Maldonado's car, correct?
Yes.
You understood because Officer Vazquez was trying to entertain whether or not Mr. Maldonado had a gun, correct?
I don't know if it was whether or not he had a gun, but whether or not there was something that was contraband, narcotics, or something else that was unlawful in the vehicle.
You understand that Officer Vazquez told Sergeant Vazquez that because of the furtive movements and the bullet hole and the evasive maneuvers, all those totality of the circumstances led Julian Vazquez to believe there may be a gun in the car, correct?
My recollection is all those items that you just indicated were what Officer Vazquez had in mind to allow him to proceed with the pat-down.
Right.
I don't recall if it was specifically stated that there might be a gun.
Sure.
I don't recall.
Right. But you disagree with that decision, correct?
Correct.
You, in this case, without rendering any legal conclusion, you expected Vazquez to allow Maldonado in the car without patting the car down for weapons, correct?
My determination was that there wasn't sufficient justification noted in Officer Vazquez's report that justified proceeding with the pat-down, and the city attorney's office concluded that it didn't either.
Not my question. As you stand here tonight, you told the commission that this incident would have let Vazquez get fired, correct?
Yes.
Because the justification for the pat-down search was not there according to you, correct?
Correct.
So you, in determining whether or not Vazquez should get fired, you would have expected Vazquez to let Maldonado go, correct?
Correct.
Let him drive off.
Correct.
You understand that detectives in this case formed an opinion that this incident let me re-ask this question so you don't form any legal conclusions. You read the report where the detective in this case, Crisfield, filed or presented this case to the district attorney's office, the city attorney's office, correct?
Correct.
You understood that Detective Crisfield was the investigating officer or the person
in charge of the investigation from the Torrance PD's Special Investigation Division, correct?
He was a detective on the case. I don't recall the special investigation. Sorry.
Okay. And you understand that Detective Crisfield, Crisfield, submitted this case to the prosecutors, correct?
Correct.
You understand one of the options for a detective is to release the suspect without submitting a case, correct?
Correct.
Meaning, if a detective thought this arrest was bad, he doesn't have to submit the case. He can just release the guy, correct? You know that as the assistant city manager, correct?
Correct.
Crisfield was never interviewed in this case, correct?
It was not contained in the material I received.
Well, you didn't read a transcript of Detective Crisfield, right?
No.
And you understand that this case was, the arrest was approved by Sergeant Kim, correct?
Yes.
He was not interviewed.
Correct.
Lieutenant Ahmad, now Captain Ahmad, AHMAD, he was the watch commander on that day, correct?
I don't recall that.
Will you recall reading the report in which his name was on there to approve the report?
I read the report. I don't remember Lieutenant Ahmad was listed on the report.
Sure. Could we please pull up same exhibit, page 7 of 66, please? Exhibit 8, under court cases, ending in 1975. The 66-page PDF. If you can please go to page 7.
Page 7 of 10 as opposed to the 7th page of the document.
7 out of 66, the PDF number, I'm sorry.
Is this the page you're looking for, Mr. Yu?
Yes, please go down. Okay. Sir, you see supervisor approving?
I do.
You see Lieutenant Ahmad?
I do to the right.
Ahmad was not interviewed, correct?
No.
Did you have any concerns that Sergeant Kim, Ahmad, Crisfield, all three of them were not interviewed in this case?
No.
All right, I want to move on to our last incident. Hopefully we can get you out of here, sir. This is the Evelyn Wimberly incident, okay?
Yes.
All right. In fact, I'll do this. You read Miss Wimberly's complaint as I showed you earlier, correct?
I did.
All right. And when you read the complaint, you understood, and I think your testimony was you would have terminated my client for that violation. Is that right?
Correct.
And in that case, if we can go to exhibit, please, exhibit 10. And there should be only one PDF document. It'll be page 27. Okay. Now, this is the personnel complaint that we just saw, correct?
It is.
All right. And she filed the complaint, right?
Correct.
Okay. When you read this case, did you review the portion of the complaint concerning that? Let me just pull up this document for you. Did you review the portion of the complaint where there was a finding by the Torrance PD of any wrongdoings?
Yes.
Okay. Let's go to page 1 of 80. Let's start with that. All right. In this case, this is the final summary in case disposition, correct?
Correct.
Now you've reviewed this document in the past?
I have.
Okay. And the top portion is just the case number, date received, date of incident, correct?
Correct.
And then there's a case told yes or no, correct?
Say that one more time, sir.
Case told. You see that on the bottom, I mean not bottom, on the second line where it says case told and has a yes or no box.
Yes,
That's talking about the 1 year rule, correct?
that's my understanding.
When you reviewed it, was that your understanding?
Yes,
Okay. And here it says no, correct?
it does.
In Mr. Garcia's case, we did not see a case telling yes or no, the same kind of paperwork, correct?
Correct.
Let's talk about this case. In this case, in the middle of the page, it has Administrative Bureau Commander's recommendation, correct?
Yes,
And I know this is blank. Is it blank?
it is.
Bureau Commander's recommendation. Is that also blank?
Counsel, for the record, I mean, we can all see it's blank, so. That was useful, so.
I understand. Did you review any documents that indicates that my client was going to get a written reprimand by the unit commander's recommendation?
Not that I recall on this one.
Is there any document that exists that's written by Captain Underwood in or about August of 2024 that indicates a written reprimand as a disciplinary recommendation?
There were such documents by Captain Underwood, but I don't recall if it was for this case.
Okay. Would it be unusual for you to review a document that has blank where in fact there was some kind of written reprimand as opposed to, in your testimony, a termination, determination?
It would be unusual.
I'm going to show you another exhibit, Exhibit I as in item. Please have it marked. I just emailed you. This is purely impeachment. If I can please publish this and then we'll move to admit if it's necessary.
I will again look to Mr. Cracker to be able to speak to if there are any objections from the department.
I don't have it yet, but I'm sure it's coming.
Counsel, I can't hear you.
Yeah, I don't have it yet, but I'm sure it's coming.
Oh, got it.
There we go.
Did you get it?
Yeah.
Okay.
I apologize if I missed it, Mr. Cracker. Did you?
If I'm completely honest, I don't recall whether this document was, at one point it was part of the exhibits and now it's not. I know there was a number of things that were moved in and out at some point. I just don't remember this one specifically.
Does the department have an objection to this exhibit?
Not as to authenticity. But it's up, I guess it's up, as I understand Mr. Yu's proffer here, it's not to be included as an exhibit, it's for impeachment, but I'm not sure what we're impeaching at this point. So I would just object on that basis.
Mr. Greco, so I understand, you're not objecting to authenticity, you're objecting on that it's not impeachment?
I don't know, yeah, at this point, I don't know what he's impeaching Mr. Santana on. I don't know what this impeaches him for.
You want me to respond?
Sure.
Well, the witness testified that there was nothing in the blank section. I think Mr. Bent even indicated it's blank. I know it's blank. In this document, it is not blank. It says written reprimand by Captain Underwood. The impeachment is to ask this witness whether or not he has seen this document, because he testified that this incident alone warranted termination. Here you have a bureau commander's recommendation of written reprimand, which is not termination. This,
I mean, I understand where you're going, I don't think that was impeachment though. I mean, you're arguing with the witnesses as far as a document that includes something different. But
it does,
I see no issue with you asking a question based on this document.
well, I am anticipating that the witness will say, well, it's impeachment because it contradicts his prior testimony under Evidence Code 780. We'll start with that. He said earlier that he would have fired Julian Vazquez for the same incident. The document tends to indicate this is a written reprimand. So to answer your question, it's impeachment based on contradiction under Evidence Code 780.
Are you suggesting that Mr. Santana wrote this document?
I'm asking whether or not he's seen it. I don't know.
No, but it would be impeachment if he had written this document contradicting himself. He told you what his perception was based on the misconduct. Somebody else may have seen it in a different way. That doesn't impeach his belief.
Well, how do you know that if I don't ask him the question?
I said to you, I didn't have a problem with you asking him questions.
Oh, okay.
You went on.
Okay, I didn't hear that portion.
Our
But it's
other,
up to Madam Chair to ultimately decide.
At this point, I'd be interested in seeing the document and hearing questions asked and answered.
So our other issue before publishing this document is not redacted and does include the first name of a complainant.
Well, I mean,
If typically we require the party to do the redaction prior to us providing it as we have it before us, would you like us to redact the first name in the complainant line?
sure, but I think her first name was testified to, and I apologize if I mistakenly or erroneously said her first name, but I think her first name is not in question. I mean, I know I have asked the witness, probably just on error on my part, her first name. There's no address, there's no date of birth. I don't know. I don't think there's any other identifying. I don't see any other identifying information on Ms. Wimberly other than her first name.
We are able to redact that first name
Okay.
if we're agreeable to that.
Yes, please.
Thank you. And we will,
Mr. Becker stipulates to the action.
Yes, please.
we will display momentarily.
It's a great redaction. Thank you. If you can please scroll down to the middle of the page, please, where it says Bureau Commander's recommendation. You see this in front of you, sir?
I do.
All right. Now, we understand the first document I showed you under the same exhibit, page 1 of 80, does not have any Bureau Commander's recommendation, correct?
Correct.
Did you review this document where it says Bureau Commander's recommendation, there's some writing underneath?
Yes.
Okay, so you did review this.
I never said I didn't.
I never accused you if you didn't. I'm just asking a question. when you reviewed this, did you take it to mean that the disciplinary recommendation was written reprimand?
From the captain, yes.
Did you produce this document to us, or did you produce the blank document that we just saw under Bureau Commander's recommendation?
I didn't produce any documents. I don't prepare the investigation.
Fair enough. Did you read what I just showed you in Exhibit 8, page 1 of 80, where it says it was blank?
The prior document that you
Yes.
showed, I did see that.
Did you have any issues or ask yourself why one document has blank, the other document has written reprimand?
I did not.
When you reviewed the document that I have in front of us, which is Exhibit I as an item, did you take it to mean that a written reprimand by the captain is a termination in your evaluation?
Not sure I understand the question.
Sure, I'll answer a different way. Captain Underwood was a Torrance PD captain, correct?
Yes.
During the date of this incident?
Yes.
When you reviewed this document, did you ask yourself or make any kind of evaluation why Captain Underwood recommended written reprimand, but you recommended this incident in itself termination?
Yes.
Written reprimand is the lowest form of discipline, correct?
Yes.
Termination is the higher form of discipline, correct?
Yes.
When you reviewed, now, did you review the blank copy of the document I just showed you under PD 2023-046?
I believe both were included in the file.
Did you ask yourself why one document is blank, but the other one has a written reprimand?
I did not.
Okay, I have nothing else at this time.
Mr. Ruther, do you have questions for this witness?
I'm nothing further.
All right, I will read you the admonishment. Other witnesses are still waiting to testify. Please do not discuss your testimony or evidence with anyone. Oh, I'm sorry. My fellow commissioners, questions for Mr. Santana? All right. Mr. Poisson.
Mr. Santana, I have a few questions for you. Have you ever recommended lower discipline than a department head?
I have.
Did the fact that supervisors consistently approved arrests and reports concern you in this matter?
It did.
How did you determine that lesser discipline would not be appropriate in this case?
Because I considered what recommendation the chief had that overrode his subordinate officers in these instances. I also considered the input from, or the perspective from the city attorney's office. And as a result of actions taken by the officer, a case was pled down despite blowing a .22 from driving under the influence or reckless. I considered all those factors in totality and made my decision to uphold the chief's recommendation, contrary to his subordinate officers.
Did you take into account that the Yusuf and Hamlin incidents occurred while Officer Vasquez was in training?
I did.
How did you determine that he was held responsible for those incidents and not a supervisor or the training officer?
Commissioner, as I've stated in my prior testimony, I don't conduct the investigation. The investigations and the recommendations of the department head come to me. So I did not know whether there was something to be pursued or whether it was pursued on another officer, and it just didn't exceed what a department head's level of discipline that they can impose if it ended in that disposition. If it ended in that disposition, something that fell within the department head's oversight.
So if a department head presents a notice of intent to terminate, and there's something in there that you don't think should have applied, are you saying that you would accept that anyway because that was the department head's recommendation?
No, I am not saying that. I have, in prior instances, not concurred with the department head's recommendation if I don't believe that it is justified. In this instance, I believe the charges were justified.
So what I'm asking is how did you believe that? For the Yusuf and Hamlin incidents in particular, the officer was in training. And so how did you determine that he was responsible for his actions and not like that discipline was appropriate in those two circumstances for the trainee?
I'm sorry, when you say use of?
Yusuf,
Okay, so
the DUI case.
Again, I don't know whether there was discipline or not that was pursued on his trainer, his FTO, his field training officer. The only case I have before me is the charges against Officer Vazquez.
Right. Yusuf was one of the incidents noted in the notice of intent.
Correct.
But you testified, and correct me if I'm wrong, that incident in itself was a terminable offense.
Yes.
So what I'm asking you is, how did you find Officer Vazquez responsible for that incident while he was under training?
Whether on or off training, an officer can still be held responsible for their actions.
Okay. Is it within your purview as a reviewer of these discipline requests, is it within your purview to ask for additional documentation or investigation, or do you just take what's given to you and assess based on that?
I can ask for additional information. Typically, I consult with legal counsel associated with that. But in this instance, I did not.
Was there a reason for that?
I felt that the notice of intent and the documentation and the information substantiated the charges, and I received nothing that overrode the recommendations of the police chief by the employee or his legal counsel.
Okay. Do you generally think that I'm curious your thought process about the fact that there wasn't any formal discipline on Officer Vazquez's record for any of the incidents, and whether or not it's how you can determine that someone had the ability to correct mistakes if they never knew that they were making them.
I didn't follow your question, Commissioner.
So if someone doesn't ever receive any written reprimands, discipline, any of those kind of things, how is it, in your eyes, how is it possible that they would ever know that they had been making errors in order to give them an opportunity to correct them?
It would be incumbent on the department to make sure that they share those insights with the employee to help them correct any behavior. But it doesn't require, there are some instances that can proceed directly to termination. And that was the chief's recommendation in this instance, and a recommendation that I upheld.
So there were, in the materials that you testified to, there were a lot of contradictions of department heads making a decision and then someone later down the line kind of saying, maybe we need to take another look at this, that kind of thing. Did the fact that it didn't seem like the higher ups could agree on anything concern you at all?
Sorry, Commissioner, I apologize, but I don't follow your question.
So
Higher ups.
yeah, so like in the Garcia incident, Sergeant Schmitz signed off on the arrest report, that kind of thing, and then later, I believe it was Lieutenant Fisher, came in and said, I think we need to take a second look at this, and said that there was a violation of policy. So originally we had a decision that there was no violation of policy, then there was a violation of policy, and then IA gets involved, and in some cases found violation of policy, sometimes not, and then termination. So were there any concerns about the like through line of those decisions?
Certainly. Why there's a recommendation for lesser termination from a subordinate, and then the chief recommended a higher level of discipline. Those are things that I considered. But what I assessed are the specific cases, the policy violations associated with those cases, and did they rise to the level to justify termination? And as I previously stated, in the end, I decided my determination was that the chief's recommendation was appropriate, and I upheld that termination.
So are you of the belief that lesser discipline for any of the instances would not have corrected the behavior?
I noted in my notice of termination or letter of findings for the Presnell case that would have done with a written reprimand. But for the others, they were significant policy violations for me, and in the end of the day, I agreed with the police chief.
I think that is all I have. Thank you.
Thank you.
Commissioner Carson.
So,
Hello, Commissioner.
you answered a bunch of questions that I had, so that's great. We're almost done. So in Exhibit 1, page 22, at the bottom of the page, it says that the department's efforts to train you, that despite the department's efforts to train you and counsel you, you continue to make unwise, unprofessional, careless, and reckless decisions as a patrol officer. I don't know if you need to read it or not. So is there a paper trail that you reviewed that showed additional training and education? Because based on what I've seen, I haven't seen that there was additional training, unless I'm incorrect on that.
So two instances come to mind. One was, I forget the exact terminology, but Sergeant Kim had noted an extensive number of issues with citations that Officer Vazquez had issued. Something like 35 citations. And Officer Vazquez was counseled to improve on his report writing, to address these deficiencies. And then on, I believe it was on the USIP, driving under the influence case, field training officer, actually I take that one back. I don't recall something specific.
Okay.
thing here, 1 second. So if, with the Yusuf incident, because he was in training, and he was counseled to get additional training, do you know that he received that additional training? Because you say it warrants termination on its own. But then his supervisors believe that it didn't and that he should be trained further. Do you know if he was trained further on that specific incident?
I believe in the FTO report that McGee authored, Officer McGee offered, he did indicate going line by line on a DUI or DMV DUI form. He also had Officer Vazquez sit with, I think it was a prior DUI expert to get some additional training. So from that, my recollection of Officer McGee's FTO report, I believe additional training was provided. But again, this was a subordinate to the chief that recommended a lesser discipline. The chief at the end was the one that recommended the termination for this. And in the end, I viewed it as a significant policy violation and upheld his recommendation.
And based on your decision-making, how many people did you interview, or did you just review paperwork and written documentation? Did you interview anyone yourself?
I reviewed all of the case files, and I held 2 scaling hearings with Officer Vazquez and Mr. Yu. Did not interview anybody beyond.
I think that's it. Thank you.
Thank you.
I have a question.
Oh, sorry.
Question. Maybe Mr. Santana.
Good evening.
When you're referring to chief, who are you referring to?
Police Chief Jeremiah Hart, the former police chief.
And when you asked for his expertise, did you know what he reviewed in regard to Mr. Officer Vazquez's case?
I'm assuming he reviewed what I reviewed, the USB files, but I did not discuss this with him. I received his notice of intent and the associated documents and reviewed them on my own.
Thank you.
Okay, I think now I can admonish you. Other witnesses are still waiting to testify. Please do not discuss your testimony or evidence with anyone. Please leave the podium at this time. Thank you, sir.
Thank you.
Madam Chair Lomas, I will respectfully direct us back to our prior discussion regarding witnesses. Now that Mr. Santana has completed his testimony, if the commission would like to revisit the need for witness Robert Dunn, if the parties would like to speak to that request at this time.
I think the issue is a little different. Mr. Yu was gonna tell us in light of the testimony whether he still felt that Dunn was necessary.
No, I'm not going to call it Dunn or Chief Dunn. I do wish to address Detective Riono's issue. I know you have to do some research. Just let me know. I believe the ball is in my court now. I know counsel's probably going to rest from here, so I'll be stacking the witnesses, and it's going to go pretty fast from here.
Are there any issues we need to discuss for this matter this evening?
No, I just want to make sure the next meeting is July 13th, right?
That is correct. And Mr. Grecker, are you done calling witnesses at this time?
Yes.
At this time, the hearing will conclude for the evening and continue on July 13th, 2026.